Hello and welcome to the Advanced Resolution Management podcast and YouTube channel. We've got a really unique episode today because we are talking about the ADR and how it is related to divorce. We've got probably the two top divorce mediators in the state of Nevada, Ishi Kunin and Roger Giuliani. Welcome to the podcast to you both.
Hi, thank you.
Thank you.
Thanks for being here, guys. I'm super excited because unlike some of the other subject matters we've covered on our podcast, I don't know very much about this. So I've got some questions laid out, some discussion topics, and you can not only educate me, but educate, our viewers and listeners. So first of all, before we get even into it, how are you both and how is COVID affecting your practices and, the fact that we're having to do it remotely these days?
Okay. Hi, this is Roger Giuliani, and thanks for asking that question, and thanks for having me as well. So obviously, COVID turned the practice of law upside down, including the mediations and ADR as well. Whereas, if you were to say in the beginning of March how many virtual hearings was a court having, it might have just been a handful, whereas now we're doing, thousands of them, right? I mean, that is the new normal, as they say. So it changed things very quickly. For one thing, it took away the save time, if you want to know the truth. I mean, let's say we had a 10 o'clock hearing today, okay? Or let's use this as an example. Let's say this was an 11 o'clock court hearing today. Sure. We would have to leave our office by 10:15 to make sure we get down the 95 or the 15, park our car, get parking, get through the metal detector, get upstairs to get to the hearing at 11 o'clock, right? Now we can simply have our computer ready and ding, 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 and here we are, we're on the hearing. So it saves attorneys, it saved us a lot of time. And while this became the new normal during COVID, I would not be surprised even after this pandemic, God willing, hopefully will be over very soon. I think this might become the new normal for us because it's saving attorneys and judges a lot of time. Sure. Conversely, a lot of judges are working remotely as well. So it's saving them time as well. It really expands to saving time, frankly. We're saving a lot of time as far as traveling to and from court, because everything I said going to court, you have to do the reverse going back, right? So it's definitely a time saver. The other thing is it also allows us to handle like more things at once, because for example, where we might have to be at the family court waiting for an hour and a half for our hearing to be called, we can be at our office doing other work, right? We can have the other computer on, work while we're doing other work, and then we hear the ding, 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 and then we can join on to the hearing. From a mediation standpoint, I've done a couple of mediations through virtual as well. I think it's, after the first 2 minutes of it being awkward, you start to get into the same role. Suddenly you get over the screen, being on two separate screens, and you start getting into the issues. So really it comes down to training, modification of behavior, and understanding that in this difficult time, the practice of law and the practice of mediation has changed, and we just have to change along with it.
Yeah. What about you, Ishi? Thank you, Roger. I appreciate that. I mean, how have you found that, like mediating on the virtual platform?
Well, so I have been doing Supreme Court settlement judge conferences since around 1996, and they call it mediation. It's truly a very coercive form of mediation. But it's only a couple of years ago that I started doing the private practice mediations on a full-time basis. And there is absolutely a difference, I think, between the Supreme Court mediations and the lower court mediations and family law mediation versus other areas of the law. The COVID, what COVID did was caused, obviously, in March, April, May, people to say, no, we're not going to meet, we're not going to do this. In most of my cases at that point, the choice was to pass things out 6 months or so rather than meet at that time, because everybody thought it's far more beneficial if we can meet in person. Well, here we are, that much time later, it was not an option to meet in person. And so slowly we began doing more and more of them through Blue Jeans or other forms online. I find the Supreme Court mediations do not work very well through this medium. They are, as I said, coercive by nature because you have a winner and a loser. And unless you've got a body sitting there and an attorney sitting next to them with the ability to lean and talk and use hands, and I'm very physical anyway, it's real hard to get a winner, even on a good day, to say, you're right, I'm willing to step back from what a judge has already given me, and a loser to not think that they'll have a better chance if they go to the Supreme Court. So those I really have found, and I've had attorneys volunteer to use their offices for us to be able to still try to do in-person mediations or Supreme Court conferences, because it's so important, I think. Health is always the paramount concern, though. With the family law mediations, and through my experience with the Supreme Court settlement program, I did 20 years of no family law cases because there'd always be a conflict because I was so entrenched in the family law arena that I got a taste of the other areas, construction law, PEI, securities, contracts, etc. In general, and this is only a generalization, I see that family law is an area where, again, that in-person becomes more necessary in so many cases than you have necessarily in those other areas. The ability of a parent to sit and to be there when Roger or I are explaining to them the bench of the court. I mean, this is, it's not just money, it's their children, it's everything that was ever important to them in their lives are now in front of them. And to have that face to face, to have a Roger or myself be able to look them in the eyes versus on a screen,
sure,
is far more powerful. So I do think, while I agree with Roger 100%, my adoptions, doing them virtually, I hate not being able to hold the babies, but it certainly saves everybody time. It saves babies from crying in the courthouse corridors. I mean, it saves so much of that.
sure.
Mediations, I just think on in person for family law is what we should be striving for at some point when it's healthy.
For sure, I totally understand that. I mean, nonetheless, you guys have both adapted very well, like the other ARM neutrals, and like that's a credit to you both. Obviously, because health is the most paramount thing for us at ARM. But changing gears a little bit, sort of like, just on a like, let's start on a broad brush stroke kind of level. What is it about family mediation that makes it such a unique and an animal of itself, like that's maybe a little bit different to other kinds of areas of law? I mean, the one thing from, a novice that doesn't know much about family law is obviously it's so personal, and it can get very, very heated, and like, you're talking about people's children. But I mean, that obviously is, I'm sure, going to be a big factor. But what are the other kind of idiosyncrasies that make it such a unique thing? Let's go with Ishi first this time.
Well, I think in family law, I've seen we never know what any judge is going to do. And now we've got an election coming up where there's going to be 6 more new ones and there's going to be a lot replaced. I mean, when we had 3 family court masters, when this whole thing started and they became judges, you didn't know what the 3 of them were going to do. So imagine now with the X number we're going to have. But the point being is we do have some absolutes. And I see it more in the family law area. You mentioned the personal, and you can't get over that personal, and you can't get over the fact that these 2 people at some point in time said, I've never loved like this before. I'll never feel like this before again. Nobody else can make me feel that way. And they stood that way in front of family, whoever they worshiped, and all. And now all of it is completely asunder. And whether it's because somebody did something betraying of the other, or whether it's just outgrowing, who knows? But if you're going to end up in a contested situation, there's generally heat involved, or else you try to resolve these without. And I think it's a heat that you don't see in other areas of the law as much. We also have specifics. Custody is a biggie. We know that at least in the last 15 years, maybe even a little longer, joint physical custody is what the judges are going to do. Now, I can say, except if you have been a proven sexual abuser, drug abuser, physical abuser, proven, not just allegations. And attorneys are zealous advocates, and sometimes aren't as outspoken as they should be to let their clients know expectations. And that's where I think Roger and I'm speaking for you too, Roger, can come in and try to put things back at a place where there's more reality and more realism in terms of what an outcome might be. And again, not that that doesn't apply to all areas, but I've seen in my personal injury, for example, Supreme Court settlement conferences and a handful of mediations I've done, there's anger at the system, there's anger at an insurance company, but there's not necessarily anger at that adjuster. There's not necessarily anger at the person representing the company in those scenarios. Whereas in family law, there's anger at the other party who's sitting at the table or in the other room down the hall. It's a level of acrimony that I don't see as readily, unless you got family relationships, I don't see as readily in other areas.
Roger?
Yeah, that was very well said, Ishi. One thing unique about family law mediations versus other types of mediations, if you have a personal injury case, one of the things you're doing is you're just negotiating a number for a settlement, right? Abbas wants $1 million, insurance company wants to pay $120,000. You're negotiating this number, and it's normally due to one causation, right? A car accident, car A hit car B, and now you're just negotiating a number. With family law, you've got dozens of issues. You've got division of property, division of debt, you've got custody, you've got child support, you have alimony, you have quadros, go on and on and on. So in any one family law case, you're sitting down and your memorandum of understanding could have 12, 2 dozen things that you're resolving, and you're playing these things in a game of chess with the parties, right? Okay, what's more important to you? You want the house. Okay, you can't afford to pay him out, so why don't we use some of the qualified money to pay him, but you don't have that. So whereas you don't, I think, have that in other types of mediations. In family law, you have all these issues, right? So that's one thing that's unique in family law mediations. You have dozens sometimes of issues that you're resolving versus just one issue. Hey, what's the amount that the adjuster is going to pay, and how much are you willing to accept, right? So you have all these different issues. So, and the other thing is, as a mediator, you have to know kind of what hits the buttons of the parties. So if custody is super important to one party, but retaining the home is really important to the other one, you've got to learn to play those things off and know what to negotiate with. The other thing is you need to really kind of, this is your turn. And I tell them all the time, I said, look, this is your time to be completely open and honest about the issues, because I don't have a dog in the fight. Okay. What we talk about is completely confidential. That's the nice thing about mediation. What happens in mediation stays in mediation, right? I said, this is going to be one of the few times where you can be open and honest about this. And I can't say anything, and no one can subpoena Ishi or I to come in and testify about. Okay, we have a shield around us. Okay, the judges are going to protect us. No one's going to say what happened in mediation that day. So it allows us to take that emotional family law client, as Ishi mentioned, and say, let's calm down a second here. Okay, look, we have to be realistic. This is your time to settle this case, because if we don't, there's going to be a whole lot of zeros on that check you're writing to your attorney to go forward on trial. So let's use this time. And what I normally do, and I think Ishi does the same thing, is we use the first half hour of mediation to just let them vent. Get it out of your system. Tell me, blah, 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 blah. I get it. You hate him. He hates her. It's just natural. They're getting a divorce. That's why you're there in the first place as the mediator. So you give them that opportunity to vent, and then you can start funneling them down into the issues. And in family law, you have all these issues, right? I mean, and a lot of times you have both the issues of dividing property and debt, along with the whole separate issue of custody. They'll come in for a mediation, and you got to decide, where am I going to bite this elephant first? Do I want to hit custody first, or do I want to do division of property and debt first? Because they are two separate things. We use them as two separate agreements. We have a memorandum of understanding for property and debt division, and then we do a custody agreement with regard to the children. One of the nice things we can do in family law mediation is decide which one we want to settle first, right? So a lot of times they'll get to mediation, and one of the spouses will say, well, I'm not budging off of primary physical custody. And as Ishi just mentioned, I mean, we have really become a joint physical custody state, absent any type of abuse and neglect or something like that. So what do? You don't say, okay, well, hands up, we give up, everyone go home. We kind of, for the moment, let's push custody aside for the moment, and let's work on the division of property and debt. Let's focus on that. And then when we show them, hey, there are things we can agree on how we're going to divide up property and debt, we can get that part of it signed. And there's a local rule, EDCR, which is 8th District Court Rule 7.50, which says once we have this agreement signed by the parties and their counsel, we've got a binding agreement. Now we can put the property and debt portion to the side, and now we can focus on custody. So
let me just stop you there. So that's fully enforceable, right?
Absolutely. Yeah. EDCR 7.50 allows the agreements between the parties to be enforced, in writing. So we tell them, one of the things Ishi and I always deal with is that the parties will get them to mediation, spend hours with them, and then they'll say, well, I want to go home and think about it. And then everything starts unraveling. You can't let them out of there. You got to say, no, let's take a break, get a granola bar, get an apple, whatever you need. But we're going to do this now, because once they leave, things fall apart. So that's always our goal as the mediators, to make sure they leave with an agreement. And there's an old saying in mediation: if both parties leave a little unhappy, you've done your job well, because you can't make everyone happy, right? You're never going to get it 100%. So that's kind of what makes family law mediations unique, is the vast amount of issues we have to deal with versus, in other cases where there's only like one or two issues.
So, and I find, to piggyback on that, I find that more times than not, especially in the higher end cases, the more money cases, I actually will separate. I'll do a mediation on the financial issues one day, and we'll pick another day for custody, or vice versa. The one that we think is more likely to get us to some resolution is generally going to be the one I want to do first.
Yeah.
Because as Roger says, you want people to feel like they can come to some agreement. But a lot of people call up thinking, half a day I can get this done.
Yeah.
Generally, Roger and I aren't done talking to you for half a day.
So this is actually quite interesting. It transitions into two other kind of sub issues. I mean, obviously, I feel like this is one of those areas where subject matter expertise from the perspective of the mediator is really important, because you have to integrate the emotions with the law to make it make sense for the attorneys and their clients. But one of the things that you both have been kind of going on about is about how many moving parts there are, and how it's really important to get to what's more important to Mr. Smith and what's more important to Mrs. Smith, in order to be able to use those chips to be able to come to some kind of resolution. So does the preparation for that mediation and the pre-mediation telephone calls, are they that much more in depth in the family law arena than other arenas, or is it the same? Anybody?
Do you want to go, Roger?
Yeah, sure. I mean, I do have to say, for what Ishi and I do, being there in person. Well, one thing we need to talk about is, I think, Ishi, you do the same thing. I bifurcate, meaning I split the parties up into two separate rooms, and I go back and forth. Okay, that's a really important touchy-feely thing. So I'll go in for 20 minutes, talk with them, come back. Yeah, I spoke to them. And I think to be able to be there in the room with them and talk to them and look at them and look at their expressions, and then be able to go back and forth, that three-dimensional aspect, I think, is frankly important. I think it really helps with what we do. Doing that online, it loses that effect online, truthfully. I think you agree, Ishi, right? I think it's different when I can walk in and see their expression, spend some time with them, go back and forth. But again, we have to adapt with the times, right?
Sure, but let's even assume we're in person, right?
Yes.
My question is, is it more of the process where, I mean, before you go in, I mean, having learned what I've learned already in the 20 minutes that we've been chatting, one thing that I need, I think is a really important part of your, both of your processes, is to kind of get to the issues of the house is more important to Mrs. Smith and custody is more important to Mr. Smith, hypothetically speaking. And to try and get to that, is it sometimes easier to make these pre-mediation phone calls with the attorneys to really get to the bottom of that before you arrive on the day? or is it something that you feel like I need to talk to Mr. and Mrs. Smith in person and see what they really are thinking? Or like, what's the process?
What I like to do in the family cases that I think I do more in depth than in the other kinds of cases is in that brief that they submit, I will tell the attorneys what it is I'm looking for in those. So I'm looking for far more detail maybe than they want to give me, because by nature, it's an easier, procrastinating, lazier kind of thing to just say, we'll talk about it when we get there. But I want to know, what is your client's proposal before I walk in there for a perfect solution? And I want to know from the other side, what is their proposal? So a lot of times that'll help me. If I get a brief and so I like them a week ahead of the time, though most attorneys will say, can I give it to you tomorrow, the next day? I like to, I'll call up if I'm not getting what I need, because you're right, Abbas. I think it's really important before we walk in there for us personally to have some empathy, to have some understanding of what their hard areas are, and to be able to approach them with that. Sure. I think it's really important.
So you touch on a good subject here, which was, again, you guys are naturally giving me great transitions, because you talked about the briefs. And I mean, obviously, a lot of the people that are going to be watching this are going to be practicing family lawyers, and some people are thinking about getting into the, or just started their careers in family law. So if you could both possibly give me your top 3 do's and don'ts, your just your top 3 tips, things that are your pet peeves that you see in briefs, and the things that you're not seeing in briefs that you would like to see in briefs that are going to help you come to that resolution. So like, and if you overlap, that's okay, because that means that point is even more important. So why don't we just go one for one? Like, let's start with Roger. What's your top tip?
Well, the timing of it. I don't like, if my mediation is on a Tuesday at 8 o'clock, I don't like to get it on Tuesday morning at 6 a.m. Here's the mediation brief. Well, that doesn't help me a lot. Right. So I do like to get them. I ask that they submit them to me at least 3 days in advance, so I have time to read it. Frankly, I like to get them so I have them over the weekend, right? And we can sit there and read them when it's quiet, when we're on our spin bike or whatever, you know what I mean? Because you want time to be able to read it. When they get it to you an hour or two, say, see, I got you the brief. I mean, that doesn't do me very good. So, and all their work that goes into it is really, it's not really being valued, because you're getting it to me so soon. When you give me a 20-page brief 2 hours before the hearing or before the mediation, I don't have time to go through that. So I like to have it early on. So get us the briefs early on.
Awesome. Ishi?
My biggest pet peeve is under weaknesses of a case, when an attorney writes that I believe all our points are supported by the law and that the judge will do what we want. And in the Supreme Court settlement ones, you'll see attorneys write weakness. We have none. 40 years, I'm telling you, you never know what a judge is going to do on any given day. So that's right. My pet peeve. Tell me what your weaknesses are. It's confidential. I will not share your weaknesses with anybody, but tell me what you're thinking.
Yeah. And then, is there anything that's idiosyncratic to a family law mediation brief that you guys would look for that maybe not in another type of mediation, if at all? I mean, it may not be, but.
Well, we have what's called financial disclosure forms in family law, and they're a standard form. And again, you have attorneys that fill them out kind of rotely, and you have attorneys that really put their heart into them and make sure that everything is listed and everything is there for you with approximate values. I think, and I've done mediations with Roger before. I know those are a very important tool for us as the mediators to look at and see what we're talking about overall. And it gives us a heads up, a head start in knowing what the properties are. So I always want an FDF, a well-completed FDF.
Right.
Sometimes that's more important. If there's no children involved, by the way, sometimes the FDF itself is as important or more important to me than anything you'll write in a brief.
Sure.
We also have what's called a marital balance sheet that we use in family law. And it's like an Excel spreadsheet, and it basically tells us tell me as the mediator how you, if you were wearing the robe or if you were the mediator, how would you divide up the assets and debts in this case? You tell me how you would formulate it, okay? Understanding community property and separate property law, how would you do it? And so when they provide me their marital balance sheets, it really is a good way for me to see where they're going, because on the marital balance sheet, it'll have husband's property, wife's property, which is community, meaning acquired during the marriage. They'll also have a separate property column for those assets acquired prior to marriage or through inheritance or through a personal injury claim or something like that. And then it gives me an idea, hey, this is what they're thinking. Oh, look, they're putting the house on the husband's side and saying, we'll give wife the equalization payment of $100,000. So I know that husband's thinking he wants to keep the home. And it gives me a good idea of what how he or she wants to divide the assets. It's giving me their answer key, right? And so when I get a marital balance sheet from both sides, it kind of gives me a good idea how to proceed with each one of them. And I love having the marital balance sheet attached to the mediation brief. So that's something I like.
You can see the disparity of where their heads are at, right?
Yeah, where are they putting the assets? If they were wearing the robe on the day of their evidentiary hearing, their trial, how would they divide up the assets? What is their win? What does that look like? And so that's really helpful.
And I don't say this to be trite, but I've heard it a few times. It's real important that if for anybody who's listening, it's not just he's and she's, it's he's and he's and she's and she's. And it's very important that it's all encompassing.
Of course.
Yeah.
So changing gears a little bit, you know, we've got like maybe 5-8 minutes left, something like that. I want to cover two topics. One is the whole pro se versus represented, because I know that's a big issue in family law mediations. And like, how important is it that someone has representation when you're dividing assets and going through this process? Or, I mean, clearly it's not mandatory. You can represent yourself, but how useful, and does it really help somebody to have a representation to go through this process? Either of you that want to tackle it, please knock yourselves out.
Okay, well, I'll start. I mean, I've seen it both sides of the coins. The difficulty with pro pers is that we aren't there to give legal advice.
Sure.
And they walk in without having consulted with a lawyer or without really any knowledge of what the law is. Where is our line? If they walk in, I'll give an easy example. Nobody, you know, they still think that women are going to get primary custody because that's the way it was in the 50s. And guy would love to have his kids, but he doesn't know it's an option for whatever reason. Is it our place to make sure that they understand if they go to court, that's what would happen? Or is it our place to massage this agreement that they're making, that one of them might really not want to do, but doesn't think he has an option to do? I do tend to be more evaluative than facilitative. I think in family law, it's more necessary. And again, I've been an attorney for a litigant in a couple with Roger, and I don't know if you do it always, but Roger tends to be more evaluative as well. I think you need to do it in family law cases. So with the pro pers, it's great if they can save money. It's great if they don't want to deal with attorneys because they want to do this between themselves without the greater acrimony, because attorneys will cause acrimony. I do like them to be somewhat informed. I might say when I get the call from Amy, for example, can you ask them if either one is at least consulted with an attorney? Because I like them to come with a little bit of knowledge, just so I can take it from there, but I'm not doing, in essence, a consultation where I'm telling them all about family law.
Got it. Roger, do you want to add anything to that?
Yeah, sometimes when they come in proper person or pro se, one of the concerns I have is we go through the process and then they say, well, yeah, I want to run this by a lawyer first.
Yeah.
And you're like, what do you mean? We've been here for 6 hours. We're ready to sign. And sometimes one party will come with a lawyer, and again, we bifurcate them, and the other side doesn't, and you get this David versus Goliath thing going on, right? Like, oh, well, she has a lawyer, and I don't know if I want to sign this yet. I do like it when they both have attorneys, because we can get her done right there, okay? You both have your attorneys. You can both be counseled. We're ready to sign this. Whereas the pro per or pro pers will come in and say, yeah, this is great. This looks good to me, but I really need to show it to a lawyer first. And then everything starts on crumbling down. So I do like it when they show up with their attorneys because we can get it done right there. But at the same time, we live in a world where not everyone can afford an attorney, and you know what I mean? That's just the reality of it. So the mediation process at least gives them an opportunity to say, okay, I want to get this done. And I hopefully, like Ishi said, they've counseled with an attorney ahead of time, but obviously it's always better to have counsel representing you, right? Because I mean, there's so many issues involved, but yeah, it can be tricky sometimes. The other thing you have to be tricky with pro pers is when they sign it and then they leave, and let's say they finish the stroke and get divorced, there's something known as NRCP Rule 60B, and they turn around 2 months later, 3 months later, anything under 6 months, and they say, I didn't know what I was signing. In fact, I thought Giuliani or Kunin was my lawyer. What did I know? I have high school education. And they just turn it around and they say, well, I didn't know, and then suddenly you're put on the defensive, right? Issue. I mean, it happens. Like, what are you talking about? You're the ones who wanted to come to mediation.
Right.
So when you have lawyers there, we don't have to worry about that because we can say, well, everyone had counsel. So, yeah.
Okay. So, like, finally, kind of on maybe a naive question from me, just because I don't know very much about this area of law. But let's say that you don't have a contentious split, and people just want to split up, but then it's not that contentious. Can you mediate before you file for divorce and then file your divorce with it already prepackaged? Like, is that a useful exercise? Is that a useful exercise to go through?
Absolutely.
Absolutely.
And
Absolutely. Yeah.
they come to an agreement. They can choose themselves to go to the self-help center and put it into one of those uncontested formats. I don't like joint petitions, but they can choose to place it into a joint petition. They can go that route. There's dangers. You've got to know you've got to understand all of the ramifications and the language and the special wordings and special phrases that have to be placed if there's children, for example, and retirement funds. But it's doable.
Great. Well, I really appreciate both of you being here and giving up your time. I've learned so much, including the fact that I can race Roger on the Peloton at some point. So thank you very much. And for the viewers and the listeners, both Ishi and Roger are available for neutral work through Advanced Resolution Management in Las Vegas. And the case manager details will be at the bottom of this YouTube video. Thanks again, guys. And hopefully I'll see you soon. Take care.
Thank you.
Everybody stay safe.
Take care, everyone.
Bye.
Bye now.